This is all this argument that was made, freedom of expression, we have a right, we feel that your policies are wrong, you have deviated from ideology. You knew the ideology. You knew that he is the Paks Pramukh. You knew what he stands for. You took his ticket, you were minister, you never raised your voice, and suddenly in Assam you go to say that no, we are very, very concerned about it. Prior to 21st of June, where is a single statement that is on the record of this case? Not a single statement. That's because you got lured into it. That you thought that maybe by using your majority in the legislature, you could actually topple the government and become the chief minister. No, I cannot go to the speaker. No member of the legislature can go to the speaker in parliament, Rajya Sabha or Lok Sabha, that I want to speak. He has no choice in the matter. The party will decide who is the party, Malaz. It's the leader. That on this issue, on cooperative societies, my member in the legislature knows more about cooperative societies than somebody else. Therefore, allow him to lead the debate. In finance, Malaz, who leads the debate in Rajya Sabha? Mr. Chidambaram. Who decides that? The party. So, Malaz, each person has his expertise on education, on telecom. There'll be different people in the house who will be espousing the cause of that subject matter because he has expertise. And who decides that? Not even the leader. Leader will put up the name to the party president or the UPA person or the party. And then they will say, okay, now you let him decide. Let him debate. So this whole argument and sitting in Assam, I can throw you out, I can throw the whip out, and I can change the leader of the house, and I'll proclaim myself to the leader of the house. What is the speaker going to do when you send it back to the speaker? And this realization dawned 2 years afterwards, Maharaj, when he was a minister and all that. So to say, Maharaj, that I am 40 members of the legislative party, I can do what I like, I am a separate group, I am a separate entity, I can remove you, it's unthinkable in parliamentary democracy. Unthinkable. And Maharaj, this per se, that's why I use the expression per se, is voluntarily given up membership of the party, per se. Supposing Maharaj, a select committee is to be formed and Maharaj, a person to be nominated. Who decides that? If 40 members of the house will say, no, because we are 40, we nominate this person. No. The whip will tell the speaker that this is our nominee on this select committee or this joint committee or the standing committee. Maharaj, what happens traditionally is, Maharaj, the members do not know the business of the house because the business of the house is decided by what is called the Business Advisory Committee. And only some members of the house of political parties are members of that committee. So every week, couple of times, every week, a meeting takes place as to what should be the business for the next week. So that's decided and then it is announced in the house. On that basis, the whip then informs the members of the house that this is going to be the business. These are the bills that are to be debated. This is the position that we have to take on the bills. Therefore, you please prepare your speeches in the context of the position of the party. That's the job of the whip. That is not the job of somebody, Maharaj, who says, I am a group leader and I will decide. That is why the whip is appointed by the political party, for that very reason.
On general parliamentary business, how specific are the whips? I mean, this is not unrelated to this case. I mean,
well, a WhatsApp message is sent to us. Three lines at the end, underlining, otherwise you have to be present, otherwise action will be taken against.
Whip.
And you come and vote, and this is how you have to vote. A 3-line whip will come. Vote for this bill, vote against this resolution. So each one under a WhatsApp, that message is sent. So we have to be present. They're very generous, because while we argue our cases, proceedings are going on, so we're not present. So they don't trouble us too much. Your Lordship knows that under the Constitution, there are areas where the governor has discretionary powers, subject to 3 exceptions which are given in Nabam Rebia. This is an area when in the beginning, there's an election that takes place. Who is to form the government? There is enough discretion with the governor. He will see as to whether there's a pre-poll alliance, and if the pre-poll alliance has majority, he'll call the leader in the normally. I mean, there are exceptions. There's a if he doesn't get a pre-poll alliance majority, he'll call a post-poll alliance. And If not, he'll otherwise see if a majority can be cobbled up by a leader who has the confidence of the House, or may have the confidence of the House. That discretion is always with him. Now, we are talking of the discretion of a governor post the formation of a government. That's the first issue. So, post the formation of an elected government, if 10 people go to the governor, what is his discretion in the matter? Because the governor has to ascertain, one, that look, these people along with others, the leadership that I will administer the oath to will have the confidence of the House. That's one criteria on the basis of which he will swear in. Two, he will ask the question, which party do you belong to? He's naturally have to ask. I am sure he will know that before even he asks that question. So he knows, that the Shiv Sena is not before him. On the 30th, he knows Shiv Sena is not before him. So what is his discretion in administering the oath of office to Eknath Shinde? Except the fact that all the 39 rebels will support, or the BJP along with the 39 rebels will oust the government and will support the new chief minister. He also knows, there is a disqualification petition pending. So your lordships will have to decide for the first time in situations of this nature, when there's already an elected government in place and there is a taint, alleged taint of a certain set of members pursuant to the fact that disqualification proceedings are pending, whether the governor can exercise discretion in a manner which will topple an elected government, not await the outcome of the disqualification proceedings. The governor could have done two things. Could have said, I know for a fact that there is a disqualification notice against you all, or against 16 of you. You who want me to administer an oath of office to want to be the chief minister. The court has given you time till the 12th of July. Please first file your reply on the 12th of July. See the outcome of those proceedings. And if there is no taint as far as your membership is concerned, I will administer the oath of office to you. That, I think, is a constitutionally moral path that the governor ought to have adopted. Because institutional morality demands that he follows that path. The Constitution, in fact, persuades him to follow that path. Why? Because there's an elected government in place, of which he was a member. He himself. Eknath Shinde was a member. So why would a governor administer oath except that he himself knows that the elected government will be toppled? That's a very serious matter according to me, You looked at the Sarkaria Commission report, your lordships will find no such eventuality, considered. The governor, which
eventualities are to be considered on experience.
That's true. That's true. Because ultimately, democracy only thrives when institutions uphold the sanctity of the Constitution. And quite frankly, and this is my personal opinion, no court, no institution should balk from that, should withhold its hands from that. Because ultimately it's the message sent by court, by institutions, that we are above the vicissitudes of fortune that come with politics. That's the only way, to gain respect within the public and to uphold the values for which our forefathers gave us this republic. But unfortunately, that's not to be. So, Malas, here there is a big conundrum, very big conundrum. So, first, Malas, the 27th order, the 29th order, then the governor. Even the governor could have stopped it. But he even chose not to stop it. So, your lordships will have to evolve some principle in the context of, because this, if Nabam Malas is not overruled, this will happen time and again. And the governor will play, I'm sorry to say, Malas, I have seen the governor, it happened in Arunachal. And we have seen, Malas, and I mean no disrespect to the institution of the governor, we have seen governors performing a more proactive role as institutional heads within the state, which has created disturbances within the polity. So, therefore, how your lordships will evolve a principle to ensure that constitutional morality is upheld is something that I leave it to your lordships. I cannot give an answer. I can only say in the facts and circumstances of this case, the governor should not have administered the oath of office to Eknath Shinde, because he was not the leader of the Shiv Sena. There was a pending disqualification petition against him. He belonged to the Shiv Sena, but had dissociated himself with the Shiv Sena. And he had no locus. Who was to go to supposing whether the Shiv Sena was to form a government with the BJP, who was to go to the governor? The leader of the Shiv Sena. That's the Paksh Pramukh, Uddhav Thackeray. It is he who would represent the Shiv Sena before the governor and say, okay, we want to join hands with the BJP. In what capacity was Eknath Shinde before the governor? In which capacity? And in which capacity did the governor accept or give him audience and administer the oath of office? And let us kindly see, Shinde has never disputed that, because he says I am the Shiv Sena, and he has never disputed that Uddhav Thackeray is the Paksh Pramukh. He is not disputed even today. So in what capacity did he go to the governor? Where did he get his authority from? Not from Uddhav Thackeray, not from the Paksh Pramukh.
Yes.
In fact, whereas what the governor does in this process, it revives the concept of a split and allows it to be alive before him, even though para 3 has been deleted. Gives it legitimacy. Now, all this is violation of 2(1)(a). All this per se, Malas. What is the speaker to decide? From the 21st of June, right up to 30th of June when he's sworn in, each act amounts to voluntarily giving up membership of the party. Each act. And under the 10th schedule, he has no defense, because there's no amalgamation. So the answer, Malas, to the question is, you have to, under the constitution, go to the party. Make all efforts. Raise your voice. Articulate your opinion. Get a membership of a substantial number of members of the party. They may not be a majority, even minority of the party with you. Claim then that there is a split in the party. Attempt to change the leadership. You can't do that. If you can muster up majority, Malas, you will become the party. If you can't muster up majority, Malas, then you say there's a split in the party. Then the election commission will decide who gets the symbol. And that also from a future date, Malas. Now, Malas, the question here, unfortunately, is there is no meeting of any party. Meeting is in party and legislatures in Assam. What is the political party and the members of the political party in Maharashtra have anything to do with the meeting legislators in Assam, Malas? And it's not even their claim. So you don't call a party meeting. You have not called it prior to 21st of June. Now, Malas, what's very interesting is that in Sadiq Ali, that's a principle that your lordships must keep in mind. the court said that I will not go into the actions that have taken place after there has been a dissonance between two factions, because each section has thrown out people in the other section and vice versa. I will take the position prior to that. That is, what was the state of the party prior to that? In this case, prior to 21st June. There's nothing prior to 21st June. There is no split. There is no attempt to split. There is no talk of split. So, how does paragraph 15 come in? Paragraph 15 comes in only when there are two factions pursuant to a split. There is no case of a split.